Hi, small business owners. It's Western Singh from Western Law Firm. So today I want to discuss about the sale of a business. As a small business owner, you have started a business, have spent your money, your sweat, and just reached to a certain level. And now you're thinking maybe because of different reason you got bored with this business, or probably you have some other opportunity to pursue at. So now you are thinking to sell your business. And so today I will talk about the legal sides of it, or how you can prepare so that you don't get into legal troubles. And first of all, means obviously you will evaluate your business, and based on your sales, your profits, and also your market, how much is your business worth. And I will not get into that financial details. That's for your CPAs, or if you are much more knowledgeable, or if you have a business broker, or if you want to do an appraisal at this early stage. That's always good. So I will discuss much more about how you can prepare yourself to enter into this phase of selling your business. So there are different documents. It's ultimately all about documents. And the main document which you have to look at is your lease agreement. And I think I will again tell you, and probably many people have told you before, that your lease agreement you should have reviewed it before you are signing it. Okay, you are now in this stage, you already have multiple obligation based on this lease agreement. So this is another opportunity to review your lease agreement. Why? Because now you are basically assigning this lease agreement to a new buyer, and there are multiple obligations attached to that. And your lease agreement will provide you a way that when you are selling this business, and if you want to transfer your lease, what's the process? So most of the lease agreement, if you are in shopping center or even in a big strip center, so your lease would provide you a pathway to what to do if you want to transfer your lease, and what are your obligations which will follow through with any kind of transfer. So you have reviewed your lease, and I think you will get struck, which usually people get struck with this one of the provision in a lease, either it's with shopping center or with big landlords, that you are still obligated to all the provisions of this lease, even if you assign this lease to a potential new buyer. And that's a very shocking thing to know, but that's your obligation. And most of the big leases have those provisions. And if you want to get release from your landlord that you don't have any future obligation, if suppose this potential buyer get defaults on this lease, then you need a release from your landlord. And most big landlords, either it's shopping center or strip center, they are reluctant to provide you those releases. Why? Because they just see that now we have 2% to go against. If suppose there is a default and the existing buyer or the so-called sublessee is not performing as per the lease, so why they just release another person who have obligation to perform this lease? So it's really hard to get those releases, but always you can ask your landlord, probably with a lump sum money, they can provide you a release. And there would be different other provisions in your lease, that how you should proceed, who you should contact, and how many days you have, and what documents you need to provide. There can be a fees which you need to provide to do a transfer. So your lease would provide you that details. And the next important document is the franchise agreement. If you are a franchise, and in this world nowadays most of the business are franchise, either it's even retail businesses or restaurants or some other kind of businesses, or even you would probably have a licensing agreement. So that's also another most important agreement whenever you're selling your business to look at, because that document will provide you again the pathway for transferring that franchise or your franchisee agreement, and also the licensing agreement. So those agreements have their own provision about what kind of potential buyer you need, what kind of financial standing that buyer needs to have in before your franchisor approves your potential buyer. And there is again series of provision about what's the process and how many days each party has to respond about particular information, or sometime your franchisor have first right of refusal, that they have the right to know that you have an offer, and before you sell it to this buyer, they have the right to purchase it on those similar terms. So you have to make sure that you review those agreements and just follow them, because if you don't follow those agreements, you will have serious problem in your transaction with this particular buyer. So the next agreement would be your vendor agreements. Either it can be a fuel marketing agreement, or it can be your agreement with the person you're buying inventory from. Usually with gas stations, you have your fuel marketing agreement, and those are long-term agreements, usually 20 years, 30 years. So now you have to look that agreement, like how my transfer will affect this agreement. Usually you do an assignment with those agreements, but again, your vendor needs to make sure that whoever is the buyer who is stepping in the toes of you have financial viability to perform those agreements. So again, you just go through application process, you notify your vendor that I am selling my business and this is my offer. And usually the jobbers or the fuel companies, they have again the first right of refusals, that they have a right to purchase your business for those same terms you are offering the buyer to sell. So you have to make sure that you are complying with those provisions. And the most important thing, if you have viewed the videos from previous series of real estate sales, again those same obligations for seller remains, that you have obligation to provide the information or disclosure to the buyer about any material thing or information which may materially affect the value of the business. So that can be a citation, especially it's much more relevant to the restaurants. If you have some health citation, you should always disclose to your buyer. On gas station side, if you have environmental issues, if you have some soil contamination, either it's minor, major, you need to disclose that to your buyer. It's always good to disclose before you are entering into a purchase agreement, because then there is no issue about that. Okay, I was not disclosed about that, then buyer cancels the purchase agreement, you are frustrated, buyer is frustrated, buyer may sue you for any cost spent, which probably the buyer doesn't have to spend. A buyer probably have known that before making a purchase agreement offer. So these are important things, and especially your financial documents are really important. And in the next video I will talk about how much to disclose, how much not to disclose. But again, you have to make sure that you are prepared with your financial document at least 3 years. That's the trend in the industry. So you should get prepared with your profit and loss statement, sale taxes, and your tax return, so that you are ready whenever you get a prospect, willing and able buyer to buy this business. And thank you again for watching this video. See you in the next video.